Hi, Shan Wu with the Undercolor of Law take on cowardice. In particular, the cowardice of these big law firms who rake in billions of dollars and why they are afraid to stand up to Trump. So we've already covered in the past one of the firms which kind of immediately took a knee and licked the boot of the Trump regime, Paul Weiss at Rifkind, and another one which stood up to fight them, Perkins Coie. But I want to take a little bit of a deeper dive because the technique that the Trump administration is using here is really very, very unorthodox historically, and that's worth understanding here. So I wrote a piece in the Daily Beast about this. We'll put it up for you, but there's a paywall there, so I want to take a deeper video dive into it for you. So like the spectacle of Trump hawking Tesla cars on the White House lawn, turning it into like a used car lot, his use of executive orders and memorandums to attack individual businesses, these law firms, for example, and individuals by name, some of the lawyers who had worked at those firms, which is why he was attacking them, really would have been unimaginable before this Trump era. Now we're dealing with this every day, crazy executive orders coming out, improper use of them. But if we take a slightly deeper look at this and look at some of the history, it's really important to understand what he's trying to do here with them and how wrong the use of it is. So an executive order, as we all know, is simply an order by the president, the chief executive, and it's a way of conducting government business. And the history of executive orders, it's kind of the good, the bad, and the ugly. On the good side, Lincoln's Emancipation Proclamation was a type of executive order, a precursor to the modern day ones, comes to mind as a good one. Roosevelt's infamous 9066 that unconstitutionally incarcerated Japanese Americans on the basis of their ancestry and race, certainly a bad one. Ugly ones are the ones where people are questioning the policy behind them and whether presidents overstepped their authority. Now, typically, the ones who issued the most were ones during wartime. Lincoln, obviously, FDR during World War II and trying to bring the country out of the Depression. And 9066 came out of wartime as well. But there have been other ones where there's been litigation, where they take it to the courts saying that you overstepped the bounds, Mr. President. Hasn't been a Ms. President yet. And there's litigation over that, and people can disagree with what they're trying to do with that. So that's something that in the past has been done. But all of those fall into the category of policy decisions, right? They're trying to accomplish some form of policy, and they've never actually named the individual business or an individual person. I mean, the Emancipation Proclamation obviously targeting a group of people who had been enslaved. Executive Order 9066 targeting Japanese American citizens. In Trump 1, there was that travel ban targeting people of a particular religion. But these take it into a very dangerous realm where they're naming the executive orders like risks of particular firms, like the Jenner & Block firm, Wilmer Hale, Paul Weiss, Perkins Coie. They're naming the businesses. It's like naming like Costco in an executive order saying it's a bad business. And the fake rationale they use for it is national security. These orders actually talk about how the law firms are engaging in things against the public interest, that they hurt national security, without going into any explanation of that. I mean, if you take the example of Covington, for example, which a big law firm in DC, that was actually not the subject of an executive order, was the subject of a memorandum. Why did they target Covington? Because they had represented Jack Smith in his personal capacity. So you want to make the argument, how ridiculous is it that because they represented Jack Smith, that the firm has become a threat to national security? So they want to hurt the firm, right, stripping their lawyers' security clearances, barring their lawyers from entering buildings, etc. On its face, very obvious, kind of like BS-y kind of reasons. But dictators in the past have always used national security as a way to oppress people. That's what they like to do. And they're the ones who decide what's in the national interest. They're the ones who want to decide that the internal threat is what is the biggest concern. And that's what they use these sorts of reasons for. So let's look at the response of these big firms. As we've discussed before, these are mega corporation type sizes. I mean, some of these big ones make $1-2 billion a year. The partners, rainmakers, making millions in salaries. Sometimes they're doing deals to bring in a group of lawyers for like $10-20 million. This is huge money. This is not like, a little mom and pop shop that's doing something here. They have resources, they have skills, they could stand up to this attempt to unconstitutionally bully them. Some of them have. Perkins Coie, for example, Jenner and Block just won a TRO. However, others have really caved. Paul Weiss caved and even sweetened the deal by giving $40 million to causes that Trump wanted them to take up in their pro bono practice. And more recently, Skadden Arps, another one of the world's largest firms, gave a great example of obeyance in advance. Before the executive order even issued, they went to negotiate with Trump, and they won up Paul Weiss. They went to $100 million in free legal services to Trump. Both of these firms ridiculously put out these statements about how we are doing something which lives up to the traditions of our firm. We're going to represent people no matter what their viewpoints are. And yet, they are agreeing to support the causes that the Trump administration tells them to support. And what do you think is going to happen if they take up some client that Trump doesn't like, right? Deal's going to be off. They're violating their little settlement. So these are amazing abdications of their principles in terms of allowing the Trump regime to dictate for them what kind of cases they're going to take. That's really unheard of. I mean, you can't say it's an ethical violation because they don't have a duty to a client, but morally, big problem here. Now, something for us to understand is some of the differences between these firms. Firms that really depend on transactional work, making deals, okay, much easier for the government to hurt them because their big clients are people who have government contracts. These executive orders are saying, we're going to look very carefully at these clients if they're paying money to these firms we don't like, meaning message to the clients, we don't like your lawyers, we're not going to make deals with you. That hurts firms like Skadden Arps, Paul Weiss. Skadden, legendary for being a deal-making firm. Paul Weiss has been really moving into that area, which has probably caused their profits to go way up. They're really worried about that because that can really hurt them. Unlike the litigation firms, and you'll see a little bit of that here, Jenner and Block hired a very famous litigation firm in DC. Boutique place, only does litigation, very famous for criminal defense. Litigation firms, they're used to going up against the government, right? They're defending corporations who are being investigated. They're defending individuals about that. They're not so scared by this. You're not going to hurt them as much economically by hitting their business clients that way because a lot of their clients might already be under investigation. So, what else are you going to do to us? But still, go back to the moral question. There was that associate from Skadden Arps who, before Skadden caved, had put in her resignation as a conditional one, saying that she wanted Skadden to support Perkins Coie. Obviously, Skadden didn't do that. I think her resignation took effect. But she called this a form of, quote, capitalistic cowardice, because she's saying that these folks are fearing for the bottom line when their firms already clear billions and billions of dollars a year in revenue. So there are economic reasons why those firms could suffer more than a litigation-oriented firm. But why didn't they fight? Because obviously the firms that are fighting are winning, and their reputations, the ones who don't fight, they're really going to take a hit. Who knows how long the memories are of the public of the young lawyers who might go to work there. I mean, right now, I don't think a young lawyer would want to go work at a place that has no backbone that way. And let's spread the accountability around a little bit, right? The clients who are saying to places like Paul Weiss, saying to Skadden, hey, looks like the administration doesn't like you, we're going to look elsewhere. What kind of backbone do those clients have, right? They are making plenty of money too with these gigantic government contracts. They could have shown a little backbone and said, you're my law firm, we're sticking with you. We don't care to bend the knee to a regime telling us who to pick for our lawyers. So there is blame to go all around, but it's important to understand the economic incentives here because these are huge economic incentives. But when it comes down to it, it's a question of what you do with this fear of your business being hurt. And so my first boxing trainer was heavyweight champion Floyd Patterson, youngest man to win the title, Floyd, first man to win it twice. And he had a very famous trainer, Cus D'Amato, who's kind of like the Obi-Wan Kenobi of boxing. Cus also trained Jose Torres, but most famously, he also trained Mike Tyson when Mike was young. Cus Floyd talked a lot about fear and cowardice. And Floyd liked to quote Cus a lot. And one of the quotes was that heroes and cowards feel exactly the same fear. Heroes just react to it differently. That's true with lawyers, too. I mean, they're ones that stand up to the administration, ones that take a knee and lick the boot of the administration. They feel the same fear about their livelihoods, no difference. But the difference lies in how they choose to act. And in the ring, I write this in the Daily Beast, when you're in the ring, when you're fighting, cowardice wounds only the fighter. And when I fought, didn't have a very successful amateur career. We'll put up a little shot of me very young with Floyd giving me some instructions. I was scared, and Floyd always told you it's fine to be scared. It means you're ready. It's how you comport yourself in the ring that matters. And if you're in the ring and you're a coward, you freeze because of fear, it only hurts you. But the cowardice by the lawyers in our society, the very people skilled and best situated and have the resources to defend the rule of law, when they're cowards, when they give in to the fear, that wounds all of us. So that's it for now. Thanks for watching. Appreciate the replies. And we'll keep an eye on how these other firms fare as well. So we'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.